Hello, can everybody hear me? I'm Pratibha Agarwal. I'm an immigration attorney with the Agarwal Law Group. I handle pretty much everything under immigration. We do green cards, we do temporary visas, we do them for individuals, and we do them for companies. So we set up this Facebook Live to just kind of answer questions that people have. We're getting a lot of individual questions, and we thought that it would be helpful to set up, a program or forum to be able to answer questions that you might have, just one-off questions here and there. Just a heads up, the way this is going to work, I'm going to be talking. I actually have received several questions ahead of time, so I will be responding to those, and also just some general information. Just with COVID-19, I think a lot of individuals are just very anxious, and we're just looking to provide some information to help maybe ease some of that anxiety. So what we're providing right now is not legal advice. I have to say that. I'll be able to explain certain situations to you, provide some general advice, but if you'd like case-specific information, just information related to your specific matter, I might need to review some documents and talk to you one-on-one. So I would suggest you call our office and schedule a consultation. We're located in Arlington, Virginia, but immigration, as most of you know, is a federal practice. So we represent individuals all throughout the U.S. And companies all throughout the U.S. And we also represent people that are outside of the U.S. So feel free to reach out to us. Our phone number is 703-348-1663. Again, since there are more people listening, people can see your chats. Everything that you have put forth to me is not privileged or confidential. So this is not exactly legal advice. So thanks so much for joining. And please type your questions in the chat if you see it. All right, so I have some questions that are kind of general that a lot of people have been sending in. And the situation here for many, many people is that I-94 is expiring. They can't leave the U.S. What can I do? What can I do? What are the options? So first, I would say just be sure that your I-94, your authorized period of stay, is expiring. So what you want to do is go on the CBP website, take a look, enter your passport number, your name, your birth date, and you'll be able to see when you have to leave the U.S., right? This is very different from your visa. So your visa is your entry document. So what you want to do is make sure that your visa, you're not looking at your visa date, you're looking at your I-94 date. So you're not, Yes, so David Track says, can I call USCIS to ask information about my H-1B? So that depends. Usually the person that filed or the company that's filing your H-1B, they are the client. And the lawyer, so the lawyer will be the attorney of record. So those are the people that can call and ask about the H-1B. So if you have specific questions about the H-1B, you should direct them to the HR person or the representative in your company that signed the forms. So you want to be able to, you want to go ahead and do that. USCIS is likely not going to answer your questions directly about your H-1B. So the best thing for you to do, David, is to go ahead, and reach out to your company representative, and they'll be able to forward that question on. If you have a general question that maybe I might be able to answer, please feel free to post. But in terms of calling USCIS, you won't likely be able to get information on the H-1B. All right. So let me get back. I'm sorry, I got distracted with David's comment. But so essentially, you want to, if your authorized period of stay is expiring, what you need to do is either file for an extension or file for a change of status, right? So that's kind of hard to do sometimes. So most people that are asking these questions are on a B1, B2 visa, and that's a tourist visa. And what they're looking to do is either extend their tourist visa or change their status to a student visa. So when you're looking to change your status to a student visa, the good thing is that the intention that you're required to have for a tourist visa and a student visa is the same, right? So what you need to intend to do is to leave the country after a temporary stay. So you can certainly file for a change of status, but the thing to be aware of is that student status is usually only approved 30 days. It only lets you stay in the US about 30 days after 30 days prior to when your program starts. So for example, if your program doesn't start till September, you may only be issued your I-94, the new I-94, in August, right? So you have to make sure you have status all from now, from when your I-94 expires, all through up to August. So what we recommend is also extending and filing for a change of status. So if you need help doing that, let us know. And what's going to be most important with both of those, and which comes up often, is you need to show an intent to return to your home country, right? So we want to package that up as best possible. And part of that will depend, what we include in that packet will depend on that specific individual. So it won't be the same for everybody. So you might want to show, number one, you have a bank. You want to show you have no family members in the US, but you have lots of family members back home. Maybe you intend to work somewhere outside of the country. So you'd be able to do that as well. So it's all good information to provide to show essentially that you're leaving the U.S. So that's the part that you need to focus on in terms of either extending your status or changing your status to a student visa status. The other thing people are asking about is what happens if I overstay? So what are the consequences if I overstay my authorized period of stay? So what you need to be aware of is there are bars to re-entry if this happens. So that's kind of what the urgency is. And you want to make sure that while you're in the US that you're always authorized to be in the US, because what this is going to do is going to keep you from being able, it's going to help you come back to the US later on. If you apply for a visa later on and you've never had an overstay, that's always going to help you. And then the other thing is, depending on the length of your overstay, if it's 180 days, if it's somewhere between 180 days to 1 year, you're barred from re-entry for 3 years. So you wouldn't be able to come back to the US for 3 years unless, there are waivers and other things that we can file. But the general rule is you wouldn't be able to come back to the US for 3 years. If you've overstayed then for more than 1 year, you would be barred from the US for 10 years. So this is why I urge a lot of people that have been calling me, is to make sure that you either extend your status or you change your status, but make sure you stay in valid status the entire time. I know coronavirus has prevented many people from leaving, but what you want to do is, take care of that. So in the future, if you'd like to come back to the US, if you would like to get a green card, you're able to do so. Priyesh, I see your question. I think you had sent me a question previously, so I'll go ahead and answer that. I believe it's the same thing. So you said, can a 7th year H-1B extension be filed based on an approved PERM? If yes, when is the 365-day period calculated from, or is it the date of the PERM application or the date of the PERM approval? All right, so your first question, it is a PERM approval is not enough to extend your H-1B beyond the 6-year period. So generally, right, so most people that extend beyond the 6-year period have an approved I-140. The others, which is the immigrant visa petition. So for those of you who don't know, the first part of the employment-based immigration process is the PERM labor certification. So the PERM labor certification essentially is the employer saying that they tried to recruit U.S. Qualified candidates. They were not able to find, so the regulation process, the labor certification process is highly regulated. So we went through the full recruitment process. We followed all the regulations. We followed all the rules. We could not find any U.S. workers that qualify for this position. So that's what PERM labor certification is. So there's a date you apply for the PERM, and there's a date that the PERM is approved. So H-1B holders can sometimes extend beyond the 6 years allowed on an H-1B if they have an approved PERM, but it's not the approved PERM alone. So the PERM application has to be pending for 365 days or longer. So let's say the PERM gets approved in 6 months. You still need to wait, Priyesh, another 6 months, and I'm sorry that this is not helpful information for you because I know you're on H-1B. And I know that your authorized stay ends before then. And right now, the I-140, the premium processing has been suspended. As a result of coronavirus, premium processing has been suspended. So the next part of the employment-based green card process is for the employer to show that they're able to support this new employee. So that's the I-140, and that's what Priyesh is referring to there. The I-140, once that's approved, you can certainly extend beyond the 7th year period. So what you'll need to do, Priyesh, is either do a change of status if you're here. If you're not here, you can leave. And I know this is extenuating circumstances, and you're not necessarily being able to leave because you can't go back necessarily to your home country. But if you can leave, you can do that. And then whenever you're eligible for an extension beyond the 6-year period, the company can sponsor you and consular process your H-1B. So that's always an option too. Manju says, what happens to a B2 visa extension, I-539, when the decision is pending with USCIS and an I-94 expires? So the B2 visa, so once to be valid, right? To be valid and allow you to authorize stay in the US, what you need to do is file before the I-94 expiration date. So let's say your I-94 expires in at the end of May 1st. Let's say it expires May 1st. You file, April 15th, or sorry, I guess April 17th. We're past April 15th now. So let's say you file for your extension application a couple weeks before your I-94 expires, and it's pending with USCIS. You're still allowed to be here because one, you filed when your I-94 was still valid. So that's the first good thing. So you're allowed to be here while they're making a decision on your extension application, right? So you're allowed to be here that whole time, and hopefully it gets approved. You'll get a new I-94, and then it's all good. If it gets denied, however, each day after the denial will be considered unlawful presence. So again, we talked a little bit earlier about the bar. And so about the reentry bar. So what you want to do is keep it under 180 days. If you keep it under 180 days, that will be good. But the issue is if it gets denied, then you're start accruing unlawful presence, and then you're not even able at that point, since you no longer have a valid I-94, you would not be able to then extend or change your status, because you would need to leave the U.S. before and consular process a visa before you could come back in. Manju, I hope that was helpful. All right, more questions. Praveen says, will H1 amended petition due to a location change supersede the previous validity of the I-94? Can I reuse the previous petition if the current one is denied? Sorry, let me read that again. Will the H-1B amended petition due to a location change supersede the previous I-94? Yes. So once you let's say you have a H-1B with company A, and it's approved and you're working there. Then you file an amended petition because you have a different location or there's a material change in the employment. So this is a new H-1B petition, an amendment, essentially, right? Let's say the amendment, you can go back. Let's say the amendment gets denied. If the first petition, the I-94 on the first petition is still valid, you can use that. You can use that previous petition if the amendment gets denied, right? As long as that period is still valid. I think that's your question, Praveen. If you want to clarify, let me know, or you can feel free to email me offline, and we'll get back to you with an answer on that. Okay. All right. So Ella says, what options would there be for an F1 student visa status with all credits done to graduate this May 2020? You have a job lined up, but you've been stuck overseas since spring break, so you've been unable to apply for OPT. If you have a visa right now, you can use that visa to come back in. Otherwise, you'd have to get an I-20 from a school, you'd have to apply, and you have to be, sorry, is that your question, Ella? I'm so sorry. You said what options would there be for F1 student visa status with all the credits done to graduate this May? You have a job lined up. Okay. Oh, so you have an OPT. So if you've applied for your OPT and you have a visa that's still valid, if you're abroad and you have a visa that's still valid, you'll be able to come back in. So as long as that visa is still valid, you should be able to come back in. If you'll have work authorization if you already have your EAD card that you've applied for and received. That will still be valid as long as the validity period is there. So I think you should be okay. If for some reason you don't have your work authorization, you can still apply for it. If you don't have your work authorization or your visa is no longer valid, you'll have to apply for a new visa to come back in based on your student status. Sankat says, can you go from H1 to B2 during a 60-day grace period and then back to H1 with premium processing? When does the B1 visa validity start in that case? No, so if you want to remain on your H1, if you're in the US and you want to remain on your H1, so I'm guessing, Sankat, that maybe your job was terminated. So the H1 is tied to a specific employer. So you're not going to go from H1 to B2 to then change of status back to H1, right? So what you want to do is remain in valid status the whole time. If so essentially you'd need a new employer to file a new I-129 petition. It wouldn't necessarily be an H-1B transfer. So there's just an issue there. So you want to, look into that. But generally the best thing to do if you're in the 60-day grace period, the best thing to do is apply for a new, try to find an employer and transfer there. I wouldn't necessarily suggest going to B2 to H1 because the other thing with going, from a tourist visa back to H1 to a tourist visa, the intention is very different, right? So if you're in an H1, an H1 visa is considered a dual intent visa, which means that you can either have the intention to live permanently in the US, so essentially eventually apply for a green card and live here permanently, or you can intend to go back to your home country. So that allows you to kind of have a green card pending and do a couple things like work here and live here and establish your residence here. The B2 visa is considered temporary. It's supposed to be for a tourist that's visiting here for a short period of time. So if you apply for a change of status, you're on an H1, you have a job here, you lost your job, and then you apply for a tourist visa, it's going to be very, very hard to convince USCIS that you want to leave after a temporary stay, right? Because then if you apply for an H1, you'll have the issue of whether you misrepresented when you applied for the tourist visa. So the best thing to do in that situation, I would suggest that you try to find another H1B employer while you're here. If you can't, hopefully you can go back and you can still use the time, whatever, let's say you have 3 years left on your H-1B, we have a 6-year max there, you can still use the time and have an employer sponsor your H-1B, and then you can consular process your visa and come back in. All right. Ajaya says, I'm on an H-1B, grace period 45 days to go. Will getting an I-20 from a school affect my H-1B transfer eligibility if I suddenly get an offer? No, I don't see that it would. But again, as I just mentioned, there's that issue. So the student visa, again, you're looking to leave the country. So an I-20 and then potentially changing your status back to a student visa, there may be that issue, but a lot of people, that don't get picked in the lottery do go ahead and change back to a student status. So that's something that you can consider. But if you're getting an I-20, that's not really a application for a visa or a change of status. You're not applying to USCIS. You're not applying to Department of State to get a particular visa. So it's not going to impact your future ability for any immigration benefit. Okay. I love all these questions. Thank you. Keep it coming. Can you apply, LSS, can you apply for OPT during your 60-day grace period following graduation of a bachelor's degree? Yes, yes. So if it's a U.S. bachelor's degree, you should be able to apply for an OPT. So you should be able to do it. You have 60 days after graduation. I believe that's correct. I will double check that. 60 days after graduation to apply for the OPT. So you should do it as soon as possible because sometimes it takes a long time to get that approval and begin working. It's better, I would suggest, you don't need it, but it's better if you have a job offer lined up and a training plan. So that's the way I would proceed if you have that option. Aishwarya says, hi, I'm on a B2 visa and it's going to end June 20th. I want to apply for extension of stay. My husband is in the US on an F1 OPT. I want to know that whether I'll have any problem or rejection if I show that my husband as my sponsor. What financial support documents will I need to submit, and what should be the approximate amount? So with any with your husband here, again, you're going to need to package your extension application with lots of very strong evidence that you need to return to the U.S. So, for example, return to your home country, not the U.S. So, for example, let's say you have children back in India or, your home country that are still there. So that's obviously very, very strong evidence that you're not going to stay here in the U.S. Again, your husband has the same intention as you right now on an F1 student visa. You have to have the intention to leave and return to your home country. So that's aligned. So that's kind of good, right? So he's going to finish his studies, finish his work, and the idea is that he's going to want to leave and return to his home country to be eligible for this F student visa. Package that evidence, make it very strong in terms of a financial sponsor. I think it's okay because USCIS already knows that your husband is here in the US, right? So, and you probably, when you applied for your tourist visa, I'm guessing that you revealed that your husband was here in the US. That's nothing that you need to kind of hide. And part of the tourist visa application is that, you want to disclose all information possible, right? And part of it, they ask you which relatives you have in the U.S., which immediate relatives are in the U.S. So I'm guessing that you've already disclosed that. USCIS already, if you were married when you came in last time, I'm sure they already know that he's there. So what I would do is, you go ahead and use him as the sponsor. But what you need to do if you're going to file for an extension of stay, you really, really do need to package that application and show a lot of evidence that you intend to return back to your home country. So that could even include things like if you have property that you own back in your home country, your residence is there. If you are enrolled in school or if you have employment abroad, all of that is going to be helpful information to show that you aren't going to stay here permanently. All right. So Manju's clarification, she wanted to confirm that the unlawful presence for B2 starts from the date of denial. Yes, Manju. So, yep, just as a recap, it's essentially you submit as long as your I-94 data is valid, right? And then you file for the extension while it's valid. So make sure you file for it a little, don't file for it the 2 days before your I-94 date ends. What you want to do, what's ideal to do, is to get that receipt notice from USCIS saying we've received your extension of stay application, right? So you'll have your I-94 date, and then you have a date that's before the expiration of your I-94 date, the receipt notice from USCIS saying now we've received your extension application and we're sponsoring it. We've received your extension application, we're processing it. And so, so you want that to overlap. So the receipt date, you want it to be before your end of your I-94 date. So do it. I would suggest if you can do it even like 2 months before the end of your I-94. But make sure, again, I keep saying this again and again, make sure you package that application to make it so strong that it's very clear that you have an intent to return back to your home country. Okay, so Praveen says, I'm sorry, Praveen, I see that You have a long question here, and I didn't answer it appropriately. Let me look at it again. So he said H1 validity at location A is valid until October 2020. You filed an amendment at location B, and you got a validity until February 2020. Now you filed an extension for location B, and you got an RFE. If the RFE is denied, can you go back to location A and work from there as the validity period was longer? Okay, so in terms of H-1Bs, this is how you have to think of it. So my answer to you is no, you cannot go back to location A. And this is how you have to think of it with the H-1s. So you have, let's say you're working with an employer, well, let's say employer A. You're working with employer A, and you have this validity period. Then you filed an amendment. You went to employer B, right? Which I think is where you are. You went to employer B, and it got approved, and now you're employer B. So once this gets approved, that previous one is no longer considered. So this one has been determined. So location B has been completely determined. This is where you're supposed to be working now, because again, H1 is tied to that specific employer or location. You're working at location B. You filed for the extension, so that's still, you're already at location B, and that's as far back as you can go. You can't go back, even though you have previous validity periods with previous locations, because that second one, the amendment that you filed, was already decided. So I would say, make that RFE as strong as possible. If it was an extension, if your job didn't, change so much from the previous time, they've already found that H-1B, the amendment, all of the details that you put in the amendment, USCIS has already found that to be valid. So I'm not sure what exactly the RFE was about, but what you want to do, you can rest on your laurels that you already were approved for that position in that specific location with the wage rate that was provided. So that's in fact very, very helpful. And hopefully the attorney, I'm hoping that your company is working with an attorney, is able to respond to all of the RFE questions in a lot of detail. So we've had a lot of success with our RFE responses. We have an incredibly high H-1B approval rate, and we're very, very lucky because the national average is about 65% approval rates for H-1Bs. So we have to be very, very detailed in the RFE and I would suggest, providing more information than necessary. I'm guessing proving you don't have so much of an option. I don't know how involved you are with your H-1B application with the RFE response. Usually for us, we work directly with the employer. We actually don't talk to the beneficiary. We request information from the employer. They pass it on to the beneficiary. There's a point of contact at the employer that the beneficiary will return all their documents to, answer our questionnaires. So we're always only interacting with the employer. So I'm guessing you won't have so much of an impact. You will be able to completely be able to provide. You might not even see the RFE response before it's filed. So unless your employer lets you do it. So I would suggest, contact the employer, the representative with the employer. Don't contact the attorney because you might create some conflict of interest issues unless you've been doing this already. And talk to the representative and see what they're providing, see what the RFE is. And hopefully the attorney has it covered. But of course, we're here. You can always reach out to us if you need help responding to that RFE. Avijit says, can I move from current STEM OPT grace period to a B1 visa to attend business meetings, since my plan was to go back and work for the same company, but I'm stuck here because of COVID-19? Yes, yeah. You should be able to do it. So the grace period, let's say you were on your STEM OPT, and I know this has happened to a lot of people, unfortunately. They're on STEM OPT. They still have a whole year to go. And their employer had to let them go because of these economic changes that we're all facing, right? So while you're in that grace period, so as long as you have 150 days or less of unemployment already, so you want to make sure that's documented well. There's no question about whether you've been employed or not. So if you're still within that sort of grace period, in terms of the cap unemployment, you're still considered technically in status. You're not out of status yet, and you're able to change to a different visa. The B1 is pretty restrictive, right? So if you're here to attend business meetings, yes, you want to make sure that you're not going to be working. You want to submit in your application that I'm not planning to work. I'm only here to observe. If you're presenting at business meetings, that's going to be different. You can't be presenting. You're just kind of present and you're there to absorb information. If the B1 doesn't work, you might try the B2, the tourist visa, which is just less restrictive. But either way, you can't be paid. You want to make sure that you're not paid because that would be a violation of status, and that might impact your ability to get future status. You're welcome. Priya says thank you. Ella says thank you. You're welcome. All right, so Swati, I'm on you. You're currently on an H4 visa and you'll lose your status in 50 days. I'm waiting for an admission to get an F1 if my home country is still on lockdown, and if I don't get an I-20 for an F1 by then in the short term to bridge the status, should I do a change of status to a V2? Yes, I would do that. If you're on an H4 visa, though, if your husband is here on an H1B, if you can extend your H4 status, that's probably the best option. If your husband is here on H1B and working, any kind of change of status to a tourist visa might be problematic, again, because of the intent that I mentioned, right? So if you have your spouse living here in the U.S., that might be a problem to show that you intend to return home. So everything I talked about in terms of, demonstrating your intent, that's going to be really, really important. I would suggest, make sure you don't accrue unlawful presence. So if that means filing a change of status application for a tourist visa, maybe do that. If you have a student visa that you apply for later on, so let's say your B2 is denied, I don't suggest filing a frivolous application, but as long as you have something pending, you are considered sort of in status as long as the initial I-94 hasn't expired yet. So you might want to consider filing that and then filing for your student visa after you get the I-20. But just know this is taking, it was taking about 4 months to process before this whole COVID-19 situation, and it could take longer. So, and you can't start your F1 until it's approved, until your change of status is approved. So just make sure, you keep all of those dates in mind and you don't do anything to violate that status. I am coming to a close here. This is we're a little bit past 5:30. I will be doing this again next week, Thursday at 5. I hope this is a good time for most people. If you have a preference on time, if this is not a good time, let me know. But it looks like a lot of people were able to join, so this is wonderful. I'm very glad this is our firm's very first Facebook Live, and I'm so glad so many were able to join and ask questions. If you'd like to contact us for anything, our phone number is 703-348-1663. Again, that's 703-348-1663. And our firm only does immigration. So we are kind of up to date on all sorts of immigration for businesses, for families, and for, and for removal defense. So people that are in court or people that are out of status and something happens, we do represent them in immigration court. Courts are closed right now. Most courts, at least the court that we're in, I'm in Arlington, Virginia, where they're closed right now. So there's not much going on with that, but ICE is still operating. And, if you need to come up with a plan, we are here. So I hope to hear from you there. If you thought this was helpful, please like our page. Go ahead and send questions ahead of time for next week if you're able to do that, and we'll definitely try to get to them. The email to send it to is info@agarwalimmigration.com. Again, that's info@agarwalimmigration.com. Thanks so much. Bye-bye. Have a good evening.